Hello again. I have been celebrating privately this week about the verdict in the Ricky Jones case, for it has removed one of the greatest barriers to free speech in Britain, one which has for centuries limited what we can say out loud in public. I have spoken before on the subject of free speech and reminded viewers that there have always been limits on what we can say in public. The example I have given in previous videos is that it has always been against the law in this country to stand in the street and urge a crowd to commit murder or take violent actions, such as burning down buildings or overthrowing the government. This has been the case for many centuries. If I address a crowd milling about in the street and tell them that we must, for example, hunt down members of the Labour Party and kill them, then the police would, until this week, have arrested me. Obviously. We all know this. But no more. This restriction upon my free speech has now been lifted. Let me explain. There are two kinds of law in this country: statute law and case law. Statute law is a law passed by Parliament, and case law is how laws have previously been interpreted during court cases. So stealing is against the law because there is actually a statute forbidding it, the 1968 Theft Act. Case law is sometimes known as precedent, and it's binding on all courts at the same level or lower than the court where such an interpretation of the law was made. I hope this is clear. If a court decides during a criminal trial, say, that I have the right to walk backward and forward along a pavement, passing and repassing along it, then that decision will be binding if a policeman tries to arrest me for just walking back and forth on a section of a road because he thinks I'm hanging around suspiciously. If this decision was reached in a magistrate's court, then it is binding precedent upon any other case held in a magistrate's court. A Crown Court trial might overturn that precedent. In the case which we have seen this week, that of a man who called for members of a certain political party, namely the National Front, to have their throats cut, it has been ruled in a Crown Court that this does not constitute encouraging violent disorder. What this means, and there is not the slightest doubt about this, is that if I were to go down to the protest being held outside the Bell Hotel in Epping this afternoon and address the crowd through a microphone and tell them that we should cut the throats of all members of the Labour Party, then this would not be a crime. I would be covered by my rights to free speech in such a case. It is impossible to overstate the importance of this development. Until this week, if I had called publicly for a mob to kill all socialists or all communists, then my feet wouldn't have touched the ground. Now I'm free to do so. I have heard that some people are minded to test out this new right to free speech in the course of some of the protests being held outside hotels full of asylum seekers, and it will be interesting to see how that goes.